Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. The brief facts leading to this application are that opposite party, who is the wife of the petitioner, filed an FIR against the petitioner and against his family, basing upon which the aforesaid case was registered. Stop. The petitioner was charged under sections 498A and 379 of the Indian Penal Code and section 4 of the Dowry Prohibition Act, read with section 34 of IPC. Stop. It is worthwhile to mention here that the petitioner was charged along with other co-accused and ultimately the petitioner along with them was convicted by the learned Chief Judicial Magistrate in respect of the alleged offences and in respect of Section 4 of DP Act, read with Section 34 of IPC. Stop. All of them were sentenced to undergo rigorous imprisonment for a period of 2 years and to pay a fine of rupees 5,000 each. Stop. The substantive sentences were ordered to run concurrently. Stop. The said order of conviction was challenged in criminal appeal before the first additional sessions judge, and while disposing of the appeal, the learned additional sessions judge set aside the order of conviction and sentence under section 4 of DP Act, maintained the order of conviction and sentence under sections 498A/34 of IPC passed by the trial court against all the accused persons, and that under section 406 of IPC against the present petitioners only. Stop. The said order of the appellate court was challenged in criminal revision. Stop. This court, while disposing of the criminal revision on 8/11/1993, passed the following orders: para. In my opinion, therefore, the examination of witness whose examination was prayed for in the affidavit dated 7/4/1993 should have been allowed, so also the petition to recall him for further examination. Stop. Accordingly, set aside the order of conviction and sentence passed by the appellate court in the criminal appeal and remand it to the appellate court for the disposal of said appeal afresh after taking the evidence of PW4 and further examination of other witnesses as may be considered necessary in the opinion of the court in connection with the proof of the allegations made in the petition, and also after examining PW4 on being recalled and after examining such other witnesses as the court may consider for necessary consideration of the evidence that may come from PW4 on his re-examination, and shall dispose of the appeal thereafter in accordance with law. Stop. Para. Thereafter the case took a different turn. Stop. The petitioner instituted a suit for divorce in the court of subordinate judge, and the same was transferred to the family court. Stop. Ultimately, the petitioner and his wife resolved their dispute on certain terms and conditions and filed an application under Section 13B of the Hindu Marriage Act 1955. Stop. A copy of the joint application was filed before this court, which has been annexed as Annexure 1 to this petition. Stop. The terms of compromise set forth in the said application were as follows: Para. There shall be a decree for divorce dissolving the marriage of the parties. Stop. The opposite party has accepted a sum of rupees 3 lakhs paid to her through several pay orders and also in cash in presence of the court towards all her present and future claim, including the share in the ancestral and self-acquired properties of the petitioner and the alleged dowry articles said to have been given before or at the time of or any time subsequent to their marriage. Stop. The opposite party hereby releases the petitioner from the obligation to maintain her on any account whatsoever. Stop.